بینەرانی خۆشەویست بەخێر بێنەوە بۆ بەرنامەیەکی دیکەی ڕاوێژ لە ڕاوێژی ئەو جارەدا میوانداری دەکەین لە بەڕێز یان فەرمۆن کە بخۆی پارێزەرە و هەروەها سکرتێری گشتی کۆمەڵەی ناونەتەوەیی پارێزەرانی دموکراتە. You are most welcome to our program, Mr. Fermon. You know that among the Kurds, generally speaking, so there are a curiosity when you are talking to somebody, you know, you want to know more about his personal life, but I don't want you to just go into details, but just tell me who you are.
Well, that's a good question. I'm a long time activist in progressive social movements, and I work as a lawyer since 1989, and I always tried to use my professional activity in a positive way, of course, to serve the causes of justice, the cause of people's rights, and the cause of human rights. And so that's how I got inevitably involved in cases related to the Kurdish people.
Yeah, and then generally speaking, you have been engaged in, I think, criminal cases in general?
I've been engaged in criminal cases, but also in other cases related to human rights issues.
But genocide, maybe, yeah?
I've worked at some point in the cases that were conducted in Belgium in relation to the genocide in Rwanda.
Yes.
And so I've been active in many other fields related to human rights, international human rights, cases conducted in Belgium against war crimes and other international crimes.
Yeah, and we know the last week, I think it was on Tuesday last week, so the highest court in, let's say, judicial court in Belgium made a decision which by this decision, so those who were accused among the Kurdish personalities, Kurdish political activists, they were, let's say, acquitted from charges against them. So first of all, I want you to just explain for our viewers that how is the work, this judicial system is working in Belgium first.
Oh, well, that
before
is,
coming to the
yes,
this special
I'll try
court.
to give some short insight in that because it's of course a complicated matter. Well, in a criminal case, an investigation is started by the federal prosecutor. Normally that is the normal way, and it's also how things happened in this specific case. The federal prosecutor then demands an investigating judge to conduct an inquiry.
Whether to take it up or not, yeah?
No, to conduct the inquiry.
To conduct
it. Actually, it's called an investigating judge, but it's a kind like a super policeman who is leading the investigation.
Yeah.
When the investigating judge decides or finds that the investigation is complete, he hands over his file again to the prosecutor. The prosecutor then brings it to a preliminary court. A preliminary court which decides on whether a trial will be held, yes or no.
Yeah.
And so we were in that last stage now, and in that last stage that the Appeal Court of Brussels decided in last March, that there was no case against these 41 Kurdish individuals, actually 40 individuals and 2 companies initially, two media companies. And so in March 2019, the Brussels Appeal Court decided that there was no case, and so no trial to be held. And the Court of Cassation confirmed that view, that decision in
2018 first.
No. The decision was March 2019, and the Court of Cassation now, at 28 February 2020, actually decided that decision should stand.
January.
In January.
January. But I think the Court of Cassation has taken up this case before as well, no?
Well, there is a prehistory.
Yes.
But actually, the case was the investigation was ended in 2015.
Yeah.
As I told you before, then the prosecutor has to take it to this preliminary court to find out or to request that a trial is ordered.
Yeah.
That the court
Yes.
orders to hold a trial. In 2016, for the first time, the first instance court said that there was no case because the reasoning was that this is not a matter of terrorism. The struggle of the Kurdish people and the struggle of the PKK is actually a non-international armed conflict on which terrorism law doesn't apply.
Okay.
That was the first decision in 2016. The prosecutor and the Turkish state, because the Turkish state was a party in the proceedings, then appealed this decision. And then a first decision by the appeal court was taken in, if I remember well, 2017, which was appealed again by the prosecutor and the Turkish state to the Court of Cassation, which quashed this first decision.
Yes.
But it went then back to the appeal court, but 3 times actually, the very first decision of the Court of First Instance, the first decision of the appeal court, and the second decision of the appeal court, which is finally the one that stands today, all say exactly the same. This is an armed conflict, a non-international armed conflict, which means that the laws of war apply and not anti-terrorism law. And so PKK cannot be considered as a terrorist organization in that view.
So now if we come to this concept of the, let's say, non-governmental party or something that's involved in armed conflict, and then according to the international humanitarian law, there are some certain, let's say, regulations for that. It will be very interesting to know that the background of that, because I think you during the this international conference in Belgium, you spoke about that historically it goes back to the Second World War. So I want you to give this information thoroughly, please.
I think it's indeed, you're absolutely right, it's a very important matter.
Yeah.
Until the Second World War, actually, generally, the law considered that any action using force against the state was by definition a criminal action. Mm-hmm. That is why the Nazi occupiers throughout Europe considered the resistance fighters as terrorists. That is why also in anti-colonial struggles prior to the Second World War, all the anti-colonial fighters were considered as common criminals or terrorists. Of course, because of the role played by the resistance during the Second World War, and afterwards the role played by the anti-colonial movements in the anti-colonial movement and wars, this became much more difficult because the resistance showed that the use of force against the state could be legitimate. And the anti-colonial movement showed exactly the same. So gradually, in international law, the idea that a non-state actor can possibly be a legitimate actor in an internal conflict, in a conflict not between states but between a non-state group and a state, could have legitimacy. Mm-hmm. That is how the Geneva Conventions further developed. There is an additional, the so-called second additional protocol to the Geneva Conventions, which explicitly refers to this kind of situation. The war on terror actually changed the paradigm again. Yeah. The war on terror actually made a step back again to the prior situation where any action against the state is considered as a criminal action. Mm. And where legitimate actions against an oppressive state do not exist anymore, from a legal point of view. Yeah. The court actually now, the Brussels court, and I think that's an important matter, even beyond the question of the Kurds, the court actually reinstates the international law as it was developed in the aftermath of the resistance movement and of the anti-colonial movement. Mm-hmm. And again says, be careful, because there is a distinction between terrorism and between a civil war or a war between a state and part of the population which can be perfectly legitimate and which cannot be considered as acts of terrorism.
Yeah.
And that is why the history of this is, I think, important, and the decision of the court actually is to somehow is re-establishing the rules of international law in a correct and in a precise way.
Does it mean that it can have a kind of international implication as well?
Well, I think yes, it should.
Yeah.
Now, of course, whether it will, yes or no, is going to depend on many different factors.
Yeah.
As you know, the war on terror, the United States took the lead. Almost all European countries, or not to say all, even beyond the European countries, followed completely the logics that were imposed by the United States. How many amongst them will take a step back now? I don't know. But at least it's a very good sign, I think, that at least one court in Europe raised this question again and said, no, the distinction, there has to be a distinction between acts of terrorism, isolated violence against civilians on one hand, and the use of force against the state in the framework of an extended conflict where parts of the population are in conflict with that state.
Yeah, but I think even this decision, I mean, before this, the latest decision, it was a kind of, there were some instances, some reference to it before. I think, I'm thinking about the Court of Justice.
The European Court of Justice.
Yes.
Yes, well, in the decision the European Court of Justice took on the listing, the terrorist listing of the PKK, which is actually a different matter.
Yes.
The listing is a political decision and not a decision of a judge.
Yeah.
But PKK actually challenged the listing before the European Court of Justice, which is the body, the judicial body that can sanction EU regulations.
Yes.
And indeed, the court...
It's a court of administration somehow.
It's a kind of administrative court, yes. It's actually a court where EU citizens can, and also non-citizens can turn, can submit to the assessment of a judge any EU regulation that has negative influence on them. And so, of course, terrorist listing with the assets freezing and everything that is related to it has negative influence on the organization or on the individual that is listed. And so the organization or the individual can ask the EU Court of Justice in Luxembourg to have a look into that and to eventually order, annul the decision, the negative decision. That's what PKK did. And in November 2018, this time, PKK actually obtained a positive decision in this matter. The European Union, unfortunately, immediately relisted PKK after the court annulled all previous decisions to include PKK in the list. European Court reinstated PKK on the list, and a new case is pending. But in the decision the court took, there is indeed a reference to the decision of the Belgian court, the prior decision, the first decision. But while that decision was not final, while it was not, it was still under scrutiny by the Court of Cassation, the reference is modest. There is a small reference.
But to clarify that we have to say that there are two separate things. They have nothing to do directly with each other. I mean, the European Court of Justice has no jurisdiction over the decision by Belgian courts?
Absolutely none.
Okay.
The decision of the Belgian court is final. There is no other body, international body, which has jurisdiction over this.
Okay.
The decision of the court saying that PKK is not a terrorist organization and that therefore individuals or organizations that are accused of making propaganda, collecting funds, recruiting for PKK, because that were actually the concrete accusations, collecting funds, making propaganda and recruiting. Actually, the court says this is, you can't recruit for a terrorist organization, but while PKK is not a terrorist organization. There is no crime in recruiting, making propaganda, or collecting funds for PKK.
Yeah. So before we go back to the historical aspect of this case, I want to know whether is there any possibility to initiate or re-initiate such as accusation or not, when, for instance, the court has decided in this way?
In principle, of course, because a criminal case is always on a specific person and on specific acts.
Yeah.
But I think with the decision we have now, it will be extremely difficult for the prosecution to revive a case and to say, no, we take it again to court, because they will most certainly have the same kind of decision. Of course, if, for example, in the framework of the collection of funds, somebody forces somebody to pay, then of course there is a criminal prosecution is possible. But not, I think it's not anymore possible, given this decision, for on the basis of the person is collecting funds for a terrorist organization, which is a crime even if you collect funds completely normally. Even if you give a receipt for every penny you receive, it's still a crime because the destination of the funds is a terrorist organization. I think that kind of accusation is finished now.
So the content of this so-called terrorist law is the same in all European countries?
No, actually it's more, it's slightly more complicated than that. There is the origin of the anti-terrorist laws, especially in Belgium, is a European framework decision. A framework decision sets minimum standards for all states,
member states,
for all member states of the European Union in fighting terrorism. Some countries previously already had anti-terrorism laws. For example, France, the UK did already have anti-terrorism laws previously. Belgium didn't have any anti-terrorist laws. Until 2003. Until 2003, Belgium dealt with phenomena of terrorism, because there were, of course, terrorist acts, dealt with those phenomena under normal criminal law. Criminal organization, murder, whenever terrorist murder was committed. Belgium dealt with this as a matter of criminality, normal criminality. In 2003, because the European framework decision actually imposed upon all states the obligation to establish anti-terrorist law, Belgium established an anti-terrorist law. Belgium copied actually word by word the European framework decision in its own legislation. Other countries said that they wanted to achieve the minimum standards by different kinds of, by different articles and different types of legal provisions. But Belgium actually copied literally the framework decision into its national law.
And it is, I mean, binding all the time. I mean, or is there a possibility for a legal, let's say, scrutiny, for instance, to changing the provisions or things like that in the law?
In Belgium, you mean, or in
in Belgium, I mean.
The legislator can always change the law.
And Parliament, for instance.
Parliament can change the law, and on different occasions since 2003 has done so by creating new types of terrorist offences, and also by adjusting some aspects of the initial law. So yes, there is a possibility to change the law, obviously. But on this particular matter, because I think there is something important to know, that is that the principle that anti-terrorism law does not apply to armed conflicts, whether they are international or non-international, is a principle that is not only enshrined in the Belgian law, it's also in the preamble of the European framework decision, which is binding on all European countries. And it's also a principle that has been instated in all anti-terrorist treaties, international treaties. So this is not a Belgian exotic thing. This is not something special for Belgium. This is a principle in all international anti-terrorist treaties, but one, the Treaty on Financing Terrorism, but that's for specific reasons. And it's also in the European Framework Decision. So this principle should apply even if it's not enshrined in the national law. So your question, is the legislation identical in all European countries? I would say this principle the principle that it does not apply anti-terrorism law to armed conflicts, should be enshrined somehow, or should be applied somehow in the national courts in all the EU states and even beyond, because it's also in international treaties that go far beyond the European Union.
Now, if we go back to the history of this case, so I want you to just give a kind of narrative from the beginning until now that we came to this decision last week.
Yes, well, you want the official narrative or you want the real narrative?
Your narrative.
Well, this case, officially it started by an investigation in March 2009. The official decision from the federal prosecutor to open the investigation is dated March 2009. But there is a story before that, and I think it's important to understand that building up to this decision. Actually, first of all, in 1996, the then Kurdish television in Belgium was raided by the police. A case was started. At that time there was no anti-terrorist legislation, so the police used money laundering and all kinds of other accusations against the then television. That case collapsed in the beginning of the century. It was still officially pending until I think 2007 or 2008, but in fact it had collapsed in 2002 or 2003. Because we then found out, I was also involved in that case at that time, we then found out that the police had manipulated some of the witnesses, and we were able to show that. And so the case collapsed. The Turkish authorities were very, very, very angry about that collapse. And tried to push the Belgian authorities to open it again, to do something about this. We know that the Turkish authorities started approaching the Belgian authorities in 2005. So when the previous case was still pending, but officially, but in fact had collapsed. Turkish authorities started to approach again the Belgian authorities, trying to push them to do something. But didn't have much success. The Turkish embassy then turned to the US embassy, asking the US embassy to put pressure on the Belgians.
So you have some documents you can...
Indeed, yes. We have, in fact, all the WikiLeaks cables which are showing all this evolution. The US embassy contacted the Belgian Ministry of Foreign Affairs, and basically the Belgian Ministry of Foreign Affairs said, the materials that Turkey is providing us to try to push us to initiate a new case are useless. We can't, there is nothing there. Right? This is freedom of expression. Under Belgian law there is no crime. The Americans then started, and that process starts in 2006, then started to organize meetings with the Belgians, where we have the reports on the meetings published on WikiLeaks, where we see that the US sent 3 consecutive high-level delegations from the United States to Belgium to put pressure on Belgium to initiate an investigation. The investigation is actually on 2 things, or the focus is on 2 things. One,
it was during the Clinton administration.
I think it was Clinton at that time. There is focus on two things. One is Kurdish media in Belgium.
Yeah.
It's a very strong focus. And the second one is actually individuals, personalities active in the Kurdish National Congress, amongst which Mr. Remzi Kartal, who is specifically named in these cables. The discussion goes on for some time, and the Belgians continue to say, yeah, but actually the evidence or the materials provided to us by the Turkish authorities is useless. We can't do anything with this. And so the Americans then say, we will help you to build a case. That process goes on for about 2 years. In October 2008, a high-level delegation, first of all, there is a trace, but we don't know exactly when, of a high-level Turkish delegation coming to Belgium. And the Belgians actually complained to the American embassy that that delegation was very heavy-handed and was trying to push them really in a very rough way. Then I think the US embassy brokered a visit of the Belgian Minister of Foreign Affairs, Ministers of Foreign Affairs, Interior, and three ministers to Turkey in October 2018. The federal prosecutor goes to Turkey in January 2009, and miraculously an investigation is opened by the same federal prosecutor in March 2009. So I think any reasonable person who reads these cables can see that there has been a build-up and US pressure and Turkish pressure behind the US, of course, to build up this case on a very high level, with very strong pressure put on the Belgians, and that actually that resulted in the formal opening of the investigation in March 2009. Then in March, I think somewhere in the beginning of, because it's 10 years ago, I think somewhere in the beginning of 2010, some of the Kurdish institutions in Brussels were raided. Some of the representatives of those organizations were actually arrested for a short time, quickly released from pre-trial detention by the appeal court. And then the investigation went on for 10 years. Or not for 10 years, for 5 years actually. In 2015, when the judge said, I have collected now all the information I had, and I hand over the case to the prosecution to see if a case can be brought. In the meanwhile, and I think that's an interesting, I would say a dramatic aspect of this case. In the meanwhile, as I told you previously, the Turkish state is a civil party in this proceedings. Under Belgian law, anybody who suffered damage from a crime can act as a party in the criminal trial in order to get compensation for the damage suffered. In 2011, the Turkish state made such statements, and from then on is officially part of the proceedings. As you know, in 2013, the 43rd defendant, who very obviously would have been the 43rd defendant, Fidan Dogan, was murdered in Paris, assassinated in Paris by an operative of the Turkish MIT. We know that now because the investigation showed the links of Ömer Güney with the Turkish, with the MIT in various ways, and even the prosecutor, the Paris prosecutor, actually refers to that in the indictment he was supposed to bring before the court in Paris if the author of these assassinations hadn't died a few days before the trial was opened. So we have a situation here where an investigation is initiated under the pressure of a civil party. The civil party murders, assassinates one of the defendants, which is, I think, an unseen situation from a point of view of criminal law. And so the rest of the story you know, because I started with that, then we went through the different court decisions. ending by the decision of 28 January, last 28 January, which makes the decision of the appeal court final. There's no other appeal, there is no other, by this decision, the whole investigation is officially closed.
So all these, let's say, WikiLeaks cables, they were taken up in a so-called, in the court, I mean.
Yes, of course, we informed the court about these circumstances, but the main discussion in the court was not on this. This was, I would say, the circumstances of the case in which the case was brought. But the main decision was actually on the question whether the conflict between Turkey and the PKK and HPG was to be considered as an armed conflict, yes or no, and as a result of that, whether international humanitarian law, the Geneva Conventions, the laws of war applied, or whether it was isolated acts of violence against the state which could be considered as terrorism. 99% of the discussion in the appeal court was about this, this issue.
Now, what the decision, is there any decision for giving the material, I mean, materially to compensate the defendants?
Oh, no,
money,
and that is, I would say, not only for these defendants. It's a problem. It's a general problem under Belgian law that there is a very small compensation possible, but only for the time you spend in jail. And very luckily, in this case, the time some of these Kurdish responsibles spent in jail was very, very short because they were almost immediately released from pre-trial detention by the Court of Appeal at that time. Because already, I think, at that time, the Court of Appeal understood very well that this was not a matter of terrorism in the sense that there was no threat for public security in Belgium. There was no threat for the public in Belgium. And so they released almost immediately. So the matter of compensation is a problem, but not only for these defendants, for all defendants who are in a similar situation.
Now, if we come to the delisting of PKK from the terrorist list in the European Union, now we know about the decision of the Court of Justice. And as a lawyer, how do you see, I mean, what the process it will take, I mean, in order to come to the decision that there is no, I mean, the problem will be solved somehow?
Well, actually, as you know, as soon, for purely technical reasons, the last decision to include PKK in the terrorist listing could not be taken up by the court. And that is for a purely procedural, technical matter. The decision to list an organization or an individual in the court has to be renewed every 6 months. That is the rule. So every 6 months, the council has to renew the inclusion in the list.
And now there is a special authority inside the council to decide about these cases, or how? I mean, who is going to put people?
I could tell you an anecdote about this. I was, formally, it's the Council of Ministers. Formally, it's a decision of the Council of Ministers. In fact, of course, this is prepared by
intelligence,
but also by a special committee of what is called the COREPER. COREPER is the Committee of Permanent Representatives. Which means actually the ambassadors to the ambassadors of the EU states to the European Union. It's something like an ambassador. They prepare the decisions. They prepare. Within the COREPER, there is a special committee that is establishing the lists. I was previously involved in a case for the founder of the Communist Party of the Philippines, who was also listed, Jose Maria Sison. And in that case, the COREPER had taken an obviously unlawful decision. The COREPER actually, or the council, but prepared by the COREPER, pretended that the Dutch court had said something while in fact the Dutch court had said exactly the opposite of what they pretended.
Yeah.
And it was not a matter of interpretation, it was black-white.
Yeah.
It was really... Someday I sat in a seminar next to one of the members of this committee who prepares the decisions. And I told him, it was a closed seminar, so we could speak openly. I said, well, I don't understand. You perfectly know that this decision is wrong because we provided you with all the materials. Did you see the materials? He said, yes, we saw the materials. Yeah, of course, we saw your letters. And I said, but what is your response then to this? You never responded to this. He said, we know you're right, but you know it doesn't work this way. Each country brings his own list. And we don't discuss the list of other countries. Because if we start discussing the list of another country, that country will start discussing our list. So actually the only thing we do is staple together the lists everybody brings, unless if there is really a very, very, very big political problem, then we have a discussion. But for the rest, our only role is to staple together what the national authorities provide us. On the national level, of course, these lists, proposed lists, are prepared by the political authorities and the secret services. And so this is the way it works. And so even an obviously wrong statement of reasons will stand because nobody wants to discuss somebody else's work. In the case now before the European Court of Justice in relation to PKK. So the case was started in 2014 for a decision of 2014. And then during the time when it was pending before the court, every time, every new decision every 6 months was included in the proceeding. But you can only do so until the oral argument in the court is held. In this case, between the oral argument in the court and the decision, there was a new inclusion in the list, which for procedural reasons could not be included in the decision of the court. So all the decisions between 2014 and 2017 are cancelled because the court said that the statement of reasons given by the Council of Ministers is not adequate. It's not a statement that allows to conclude that PKK is, it's not elements, information that allow to conclude that PKK is a terrorist organization. But the last one they couldn't include it in their decision. Although it's based exactly on the same statement of reasons as all the previous decisions, because the statement of reasons don't change. They are identical. So for technical reasons, that statement could not be cancelled. And furthermore, as the Council of the European Union has done it in previous cases, as soon as the previous series was cancelled, they took a new decision, putting PKK again on the list, with identical statement of reasons as the ones that were found
already
unlawful or unsound by the court. And that is a practice we've seen it before. They've done it before with other organizations and individuals which they want to keep for political reasons on the list. Then they simply ignore the decision of the court and relist the person or the organization on the same grounds, with the same statement of reasons, and the person or the organization has no other choice than to start a new case. And that is actually what has been done. A new case was started and is pending now. But I'm quite confident that it will be very difficult for the court to completely change its opinion because they said this statement of reasons is no good. There's absolutely no reason why that same statement of reasons now suddenly would become sufficient. And also, that's another aspect, the Council of Ministers also appealed the decision. So it's also pending on the appeal level. And I don't know how that will, because the European Court is working very, I would say, thoroughly, which means that it takes a lot of time before a decision is given. So I don't know when a new decision will come.
Yeah.
But I'm very confident that the decision of the court of first instance at least will be the same as the previous one, because there's no reason to depart from the previous point of view.
In such cases, for instance, we know in the United States the lobbying has some kind of effect because, for instance, there was an Iranian organization, Mujahideen Khalq,
Yes.
which was delisted. It was in the terror list of the United States, but it was delisted later. Is there such possibilities in European level?
Let's say that, of course, public opinion plays a role.
Yeah.
That's clear. On the Iranian Mujahideen, to be very honest, I think what played more a role than lobbying is the fact that in the specific situation at that time of Iraq and Iran, it served the US and UK policies not to list the Mujahideen anymore. So I think it was more a policy decision than a result of lobbying.
Yeah.
And that might be different for PKK, because I'm not sure that the US has the same stand on PKK as on the Mujahideen. But of course, public opinion plays a role. That's clear.
Yeah.
So if you can show to the public opinion that a decision to include an organization in a list or to prosecute individuals in a criminal court from an organization for being or for participating in activities of a terrorist organization, if you can convince the public opinion that the organization is not terrorist at all, that it's a completely different matter, then of course that can play a role in the way politicians will decide on the list.
Yeah. So if we can wind up, what you are going to say more, I mean, in few words.
Well, I think this decision actually gives now a window of opportunities. A window of opportunities to the Kurdish organizations, because especially in Belgium at this point, Kurds shouldn't be afraid anymore of expressing themselves freely on the conflict with the Turkish state. What they say cannot be considered anymore as propaganda for a terrorist organization. Kurds can organize freely, of course within the boundaries of the law, that is clear. But up until now, any kind of activity in favor of the Kurdish cause was at risk of being criminalized. I think that is finished, and that's a window of opportunities. The second point is, I think there is also a window of opportunities for the European countries, because as I said many times previously, conflicts are to be solved, terrorism has to be fought. Yeah. Which means that there is an opportunity here to change the paradigm and to approach the situation as a conflict, in which case normally states present their good services to try to help a solution to be found. Yeah. Which is of course a different matter than fighting terrorism. And this decision, actually, by saying this is a conflict and not terrorism, offers us a fantastic opportunity, I think, first of all to the Belgian authorities, but by extension also to the European, to the authorities in other European countries, to stop the criminalization policies and to approach this as a conflict and to see how, by diplomatic means, they can help the parties in the conflict to start a dialogue and to find a political solution for this conflict. So from that point of view, I think this decision could have very positive consequences, including in the political field, if it is taken seriously and with sufficient consideration.
So on non-related question is about the founder or the ex-director of WikiLeaks, because we refer to him, as you know, he's vanquishing in a jail in UK, and I mean, it's his handing over to him to the Americans is pending, I think. So what do you think as an organization? I mean, International Democratic Organization.
My organization, the International Association of Democratic Lawyers, has supported Julian Assange from the very beginning.
Yep.
Because we think obviously there is a kind of criminal law conspiration against him to try to punish him not for so-called sexual crime committed, allegedly committed in Sweden. Everybody knows that that is a pretext actually to punish him for what he does. Yeah. The PKK case shows how useful WikiLeaks is, because of WikiLeaks we understand how this case was built up. And so this is essential information for all citizens. So we supported Julian Assange from the very beginning on this question. We requested from the very beginning his immediate release and also the end of all prosecution. Of course we oppose the extradition to the US. We've been conducting, we do have an observer mandate in the ECOSOC of the United Nations, which means that we do have the possibility to organize activities in the Human Rights Council in Geneva, and we have been doing throughout the years several seminars on the case of Julian Assange, requesting attention and trying to convince states to weigh on first on the Swedes and now, of course, also on the British, to release immediately and to stop all forms of persecution against Julian Assange.
Okay, thank you very much, Mr. Fermon, for your participation in Rawej.
Thank you for having me.
I wish that you continue to support the people in the world with your democratic views. Thank you very much.
We'll try to do our best.
Thank you
for having me.
Thank you. بینەرانی خۆشەویست بەم شێوەیە دەگەینە کۆتایی ڕاوێژی ئەمجارەشمان هیوادارم قسەکانی بەڕێز یان فەرمۆن توانی بێتی تا ڕادەیەکی زۆر ئەو نمونەیە کە ئەو ناحەقەیە کە دەرحەق بە پێکەکە و بە تێکۆشەرانی کورد هەبوو ڕوونی کردبێتەوە تاکو ڕاوێژێکی دیکە لای ئێوەمان خۆش.